Yeah. Yes.
Mic check 1 2 1 2. Gonna be with the king. What is you gonna do?
Mr. Barnes, you doing a mic check over there?
No. I was singing a song.
Oh, okay. Well, now's not the time, okay?
All right, my bad. I'm sorry.
Thank you. Okay. Christian Morrell. We're on the record in the matter of the people of the state of Michigan versus Christian Alex Morrell, file number 22-02108. Council appearance.
Brian Ring on behalf of the people.
Oh, no, you don't have to stand.
You guys all don't have to stand. You guys just come over here.
Not unless they want to be defendants. Your Honor, Harry Mihas on behalf of Christian Morrell. Mr. Morrell, state your name. Christian Morrell. And Your Honor, my partner Nicole Smith is also present. She is also representing Mr. Morrell. My P number is 66417. Hers is 62475.
Thank you. Today was the date that was set for a final pretrial on a domestic violence. Do we have the necessary witnesses here?
Yes, we do, Your Honor.
Okay, are we proceeding to the trial on this?
Your Honor, at this time, the client wants his rights and go to trial. We understand we have a trial date next Tuesday, and the witness list and exhibits are due Friday.
That is correct. So we'll continue the trial. 8 a.m. Is the court time for October 25th. Do you have any questions today? Okay, any additional matters for the record?
There's no good, Your Honor. None, Your Honor. Everything's been quiet on the bond front, so there's no issues to bring up.
Sounds good. Thank you.
Thank you.
Have a good one. We're off the record on that matter. Okay. Good morning, Mr. Green.
Good morning, Your Honor.
What matter are you here for?
I am covering for attorney Michael Cronkrite of the Rolando resentencing.
Okay, sounds good. Let me handle another matter first. And we're ready to call on the jury on Heather Thalen.
Yes, Your Honor.
Yes, Your Honor.
Okay, is Heather here?
Yes.
Okay, and the witnesses are here.
Yes, Your
Yes.
Honor.
Please, Heather. We called in some juries before and found out people weren't here. Okay, we're on the record in the matter of the people of the state of Michigan versus Heather Renee Thalen, file number 20-00608. SM appearances for the record.
Brian Ring on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Heather Thelen, who is present and standing to my right.
Thank you. Today's a date that was set for a jury trial and it is 8:39. Do we have our necessary witnesses here?
Yes, Your Honor.
Okay, and we're ready to proceed to call on a jury.
Yes, Your Honor.
Okay, do you have any questions at this time, ma'am?
No.
Okay, you need to sit tight, you cannot leave the building, okay? And we're gonna call on the jury. I gotta finish my morning docket, but my expectation is that shortly after 10:30, we will begin jury selection, okay? Any additional matters before we go off the record on this?
Nothing on the people, Your Honor.
No, no defense.
Okay, we're off the record. We can call the jury. Well, did you need to speak to Mr. Barnes?
Probably sure.
There's 2 sentences.
Over sentencing. Yes, I do.
Okay.
Read on the, okay.
Okay, we're on the record in the matter of the people of the state of Michigan versus Rolando, Robert Ruiz, file number 22-00606. So can I have your first?
Brian Ring on behalf of the people.
Good morning, Your Honor. Vince Green on behalf of the defendant, Rolando Ruiz, and as I indicated, I'm covering for Michael Cronkite, and I think Mr. Ruiz will waive his presence here this morning. He had another conflict.
Okay, today was a date that was set. My note says we're gonna continue the trial, but I think that there was a plea snuck in there somewhere.
Yep.
After my note says no plea after October 11th.
Yes, Your Honor. I was out of the country the 6th through the 11th, and I picked up the case on the 5th. I got back on the 11th, and I worked with Mr. Concrete on the 11th all day. And the morning of the 12th, we came to an agreement, Your Honor.
Okay, do you have a plea sheet?
I do not have a plea sheet, Your Honor.
What's the offer?
The offer is to plead to an added count 4 of operating motor vehicle with a high BAC. That's 257.6251C. And a kilometer no upfront jail. And then we dismiss the remaining 3 counts.
Can you get my plea sheet, please? Okay, and Mr. Green, your client has considered that offer and wants to accept it.
I believe he will accept that, Your Honor. I had an opportunity once Mr. Cronkite sent over the discovery to me yesterday evening and the complaint. It looks like a very satisfactory resolution of this matter.
Where are we adding account 4 of operating with IBAC? Account 4 is operating with IBAC.
Oh, it looks like it was already added then, Your Honor.
Okay. Okay, sounds good. So he's actually just pleading to count 4. We don't have to add account 4. Correct?
Correct, Your Honor.
Okay. Mr. Ruiz, is that what you want to do?
Yes, Your Honor.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Okay, you can put your hand down, sir. Okay, Mr. Ruiz, you have the right to be represented by counsel. You have retained counsel, but you have Mr. Green here today for the purposes of this hearing today. You have the right to proceed to a trial, and you have the right to have a jury trial, or you can waive the jury trial and have a non-jury trial. You have the right at trial to be presumed innocent until proven guilty. You have the right to remain silent and not have silence be used against you. You have the right to see, hear, or question any other witnesses that the prosecution intends to call. You have the right to call your own witnesses or present evidence at trial that you believe would further a defense to these charges. You have the right to have each element of the charge being brought against you proven by the prosecutor, and they have to prove it beyond a reasonable doubt. In order to accept the offer to plead guilty to count 4 and have the rest dismissed, you have to give up all of those rights today. Do you understand that?
Yes, Your Honor.
And you wish to waive your rights?
Yes, Your Honor.
Is anybody threatening you to get you to waive your rights?
No, Your Honor.
Has there been any promises made to you in exchange for you waiving your rights?
No, Your Honor.
Are you currently on probation or parole?
No, I'm not, Your Honor.
You understand that a guilty plea can result in a conviction that you will need to either report to your current employer, or you may need to put it on a future job application.
Yes, Your Honor.
Okay. You understand that a guilty plea can result in a conviction that may have impact on any immigration status you may be seeking.
Yes, Your Honor.
You understand that this is a misdemeanor with the maximum penalty of 180 days in jail and or $700 in fines and or 360 hours of community service and rehabilitative program and vehicle immobilization. You understand that?
Yes, Your Honor.
Okay. And I recognize there's a sentencing agreement, the Killebrew agreement of no upfront jail. That's an agreement that's between you and the prosecutor. I'm not a party to that. You understand that?
Yes.
That means that if at the time of sentencing, I decide that I am going to sentence you to jail, I would give you the opportunity then to withdraw your plea, okay?
Okay, Your Honor.
Okay, and are you pleading guilty to count 4 because you believe you are guilty?
Yes, Your Honor.
Okay. As to count 4, operating with a high BAC, how do you plead?
Guilty, Your Honor.
On a factual basis, please, Mr. Green.
Yes, Your Honor, let me, I'm sorry, let me get to the complaint. There you go. Well,
Oh, yes, please.
okay. Yeah, I'm sorry, Your Honor. I thought this, but I've got it in front of me, the complaint. Just give me a second. I thought this was a sentencing this morning, not a plea, so.
No problem. Mr. Ruiz, on or about October 30th, 2021, were you operating a motor vehicle upon the area of Oakland and Westmoreland?
Yes, Your Honor.
Is that located in the city of Lansing, Ingham County, state of Michigan?
Yes, it is, Your Honor.
Okay, and did you come in contact with law enforcement?
Yes, I did, Your Honor.
Okay, and that roadway that you was operating on, that was open to the public?
Yes.
That was a public highway, and were you under the influence of alcohol at that time?
Yes, I was, Your Honor.
Okay, what were you drinking?
I had some shots and some beer, Your Honor.
Okay, And you were stopped by the police?
Yes.
Why were you stopped?
There was a call to the where I left about a confrontation, and when I turned the corner, I turned off the street, and person in front of me hit their brakes. I hit my brakes, so the cops seen that and pulled me over.
Okay. Okay, and did you submit to a blood draw at that time?
I did after I did the breathalyzer outside the car, and then I did the blood draw.
Okay, and are you just in dispute that your blood alcohol content was 0.180 grams of alcohol?
Yes.
You're disputing that?
Oh, no. I'm sorry, Your Honor.
Okay. Any questions from the prosecution?
No, Your Honor, I believe that is the factual basis. For the record, Your Honor, Eilish Gallagher, I'm the present people. Thank you.
Thank you. Any additional questions, Mr. Green?
No, Your Honor. I'm satisfied. Thank you.
Thank you. The court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing is going to be December 6th at 8:30 in the morning. Mr. Ruiz, you need to turn yourself into probation within 48 hours so that they can prepare a pre-sentence report and recommendation as to how you should be sentenced. Today is the 18th, and it's currently about 9 o'clock. You need to turn yourself into probation by October 20th at 9 o'clock in the morning, okay?
Okay, Your Honor.
And did you already do or have a substance abuse assessment completed?
Oh, what?
Have you had a substance abuse assessment?
No, I haven't, Your Honor.
Okay, you're being ordered to undergo a substance abuse screening. So that, I thought that you were back in April, we're supposed to have a screening done, but it looks like that didn't happen. So you'll be ordered to undergo one. But probation can provide you information as to where you can get that done, okay?
Okay.
Do you have any questions for the court at this time?
I just report downtown for probation, right?
Yes, you're going to report to probation so they can give you the questionnaire that you need to complete and set and schedule your interview, okay?
Okay.
Any additional questions?
No, Your Honor.
Additional matters for the record, counsel?
Not from the defense, Your Honor, and I'm sending Mr. Cronkite an email right now.
Very good. Thank you so much. We're off
Thank
the
you.
record.
Thank you, Your Honor.
No problem. On the record in the matters of the people of the state of Michigan versus Jonathan Troy Barnes, file numbers 22-01931 and 22-02004. Council appearance.
Thank you, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of defendant Jonathan Barnes, who is appearing separately from the Union County Jail.
Okay, this was the date set for sentencing on both files. And you received the pre-sentence reports.
I did, Your Honor.
Do you need to make quick changes, updates, or any corrections?
No, Your Honor.
Okay, you can make allocution.
Thank you, Your Honor. Mr. Barnes would like the court to consider him for a term of probation or time served. It sounds like he has recently been trying to make strides to take care of his issues. He was supposed to have an appointment with community mental health this morning to get set up with a case manager so that he can get mental health, substance abuse treatment, and a payee. He understands that he has a lengthy criminal history. He understands his relationship with the law. He has had issues hearing in court, and obviously he has a pending felony, but that's not right now. It's not holding him in jail. What's holding him in jail is this offense. So he would like to be given that opportunity, Your Honor, to be put on probation. Thank you.
I understand he would like that opportunity, but what would make him a good candidate?
Mr. Barnes, did you hear that?
I just I guess it'll give me opportunity for some to pay my fines and restitution and court costs.
I want to know what would make you a good candidate.
Because I guess because I'm mature. I'm more mature in my life right now, and I want to do things the right way. Yeah.
You're more mature in relation to what, sir? To the last time you committed an offense, or?
Yes, that, and just want to be abstain from committing criminal acts or crime, and just live a righteous positive life.
What prompted this maturity? What can you tell me that you've done to demonstrate maturity?
Just knowing that is not like is not beneficial to me to as far as trying to accomplish my goals, as far as going back to school to be a doctor. I mean, get a doctorate or a degree, and just accomplishing goals, establishing whatever wealth or whatever, and accumulating materialism or whatever. I can't achieve what I can achieve out there in here, or doing the wrong thing.
I think you knew that for a long time, sir. That doesn't, to me, demonstrate that you have matured. I've reviewed the pre-sentence report and your extensive. I don't know that I've seen a criminal history this long, to be honest. Your extensive criminal history report, which spans multiple states. What we have here, at least in the pre-sentence report, is the impression that you are high risk, that you are a poor candidate for community supervision, and that you had elevated scores in almost every domain that was considered.
Probation switch.
Nothing about this report, your criminal history, your current situation, gives the court any indication that you would be successful on a term of probation. You have some needs that I think extend well beyond what our term of probation would be able to address, because you demonstrated that you can't supervise yourself. You don't make good choices, sir.
No, I just asked her to add on the probation just so I could have some kind of structure, because I mean I was really going for because I had 71 days, and I know I have to have some fines and restitution and court costs or whatever, and I just told her to add on probation just so I could have some kind of structure, whether it be 6 months or a year or whatever. I just need structure in my life, you know what I'm saying? But I don't need incarceration in a penal facility when whatever when I have so much a business to attend to. That's all. I wasn't like trying to, I know I have a extensive criminal history, but I suffer from a not like trying to downplay it or nothing like that, or make excuses for it. But I've been mentally ill for a number of years.
I think we recognize that you were supposed to have an evaluation back in August. Did he have that? With CMH?
Yes. No, I just had it in October. I just had it like last week or something. I have an appointment this morning at 9:45 with CMH.
Yeah, you know why you didn't have it back in August when you said?
Why?
Because you didn't turn yourself in to do it. You were missing court. We had to bring you into custody after several failures to appear and to make you be compliant. I'm not dealing with that during the term of probation. You do not have enough capability, sir, to control yourself or to follow the structure that would be required for probation. You don't have any employment. I don't even know how employable you are. I don't know what skill sets you have. You have some unaddressed mental illness concerns and substance abuse issues. I think it's most appropriate that you be sentenced to a term of jail time in order to participate in programming from the custody of the jail.
I would much appreciate it. Yes, sir.
Recognize that you've been in custody for, I guess, at this point, over 71 days. It was 71 days at the time of the.
Oh, Betsy Earl Vidig or Betsy?
I believe.
Mary Elizabeth. My mother's name goes by 4 different names since her arrest in the 90s.
This jail doesn't offer programming as far as like.
I'm sorry, I didn't understand your question.
I never known this jail to offer a program, but the CATS program.
For substance abuse or for mental health? What kind of program are you talking about? Because you need.
I'm supposed to have all my services and everything were like everything was supposed to. I was supposed to have an appointment with this morning at CMH to start everything. I'm not even supposed to be. It was. I didn't even lose track of the date. They moved the date up to past the 11th to or whatever, because never mind, it don't matter, man.
Okay. The sentencing of the court will be 365 days, credit 71 days. I'm going to have you screened for substance abuse treatment while in the custody if you've not already undergone that. You need to also be screened by community mental health or for mental health treatment while you're in the custody. You will not be able to earn early release. You also will not be able to be released from GPS tether. You can, however, be released if you're accepted into some substance abuse in-house programming, okay?
Yep.
I don't see where there was restitution on it. Did I miss something?
I don't believe so.
Okay, yeah, he mentioned restitution multiple times. I know there was an MDOP. There's no restitution on these, correct? One was Kroger. I don't think that they submitted anything. Okay, I don't see where restitution was ordered. However, on each file, there is. I will waive discretionary fines on both files. There's a $75 crime victim rights fee, which will be assessed on each, and a $50 state minimum cost will be assessed on count 1. Do you have any questions right now about your sentencing, sir?
No.
Okay, you can make an appeal to the circuit court within 21 days of the date of the sentence under MCR 6.625B, okay? Any additional matters for the record?
No, Your Honor, thank you.
You're all set, sir. Okay, we have a bunch of show causes. Hi. Mr. Vallejo,
Yes.
okay, we're on the record in the matters of the people of the state of Michigan versus Vincent Vallejo, file numbers 21L 265551 and 22-00068. Mr. Vallejo, both of these were set for show cause because you still have a balance on them both. On the file number ending in 00068, you still owe a balance of $50. And then on the other file, you owe a balance of $183.
Yeah, I just paid that yesterday, like about 1 o'clock in the morning.
Which you paid both of them?
I paid, well, I just only paid because I had set an agreement for $25 each every 2 weeks. So I
Okay.
just had paid that one yesterday about, like I said, it was around, I say approximately 1:30ish in the morning.
Okay, so you paid $25 yesterday, or really this morning at 1:30?
Yeah, well, it's 50, so it's 25 each for both
Okay,
bankings.
okay, and so you're gonna get back on your schedule of $25 per week?
Yeah, every 2 weeks because I get paid every
Every
2
2
weeks. Yeah, because I get paid every 2 weeks.
Okay, so I'll note here that you've made a payment of $25 on each file and that you'll continue with your bi-weekly payment plan, okay?
Yes, ma'am.
Do you have any questions?
No, that's it.
Okay, you're all set. Thank you.
Yep, thank you.
Thank you. Unless there's any other questions. No, it's warm in here.
Sure.
Where are they heading next?
Down to Laco. We do a tour of the Capitol, then we
It's gonna
end up
be-
going to.
It's gonna be more fun than being here for sure. Well, it's nice to meet you all. Have a
Thank
good
you.
one.
Have a
Thank you.
good day. Thanks.
You're really pretty, by the way.
Oh, thank you. I don't think that the other show classes are in conduct.
morning. Who's on the iPhone?
Oh, I know that case.
Sir, can you hear us?
Yes, I can hear you.
What's your name, sir?
Robert Kane.
Oh. Yeah, no worries. I just wanted to get the case. Yeah.
Okay, Mr. Kane will be with you in just a minute, okay?
All right, thank you.
Okay, Mr. Kane? Oh, Mr. Kane, you're muted. I can't hear you.
Can you hear me now?
I can, thank you. We're on the record in the matter of the people of the state of Michigan versus Robert Earl Kane Jr. This is file number 21-02822. Mr. Kane, this matter was set for show cause today because you still owe a balance of $125. I think you originally said you were going to pay $20 on September 13th and $20 per month until paid in full, but you haven't made any payments.
I had lost my job due to my kids having COVID. I am working again, just waiting to get paid.
Okay. I know here that you were temporarily unemployed. When do you think you can get back on your payment plan?
I can get back on the payment plan next week. And I actually can give $60 next week.
Okay, very good. I note here in the file that you'll make a payment no later than October 28th, okay?
All right, thank you.
Thank you. Have a good one.
You too. Bye-bye.
Bye. Mr. Matson. You know, they gotta do something about this heat. Tell her about the temperature here? I don't know how we're gonna have that many people in here with this heat. They gotta come and adjust this heat ASAP.
This is a check for my microphone.
Yep, I can hear you. Edward, what's your name, full name?
Edward Staholski.
Okay, thank you. This is Vincent Matson. Ms. Donnelly, did you need to speak to Mr. Matson? I don't know where she went. Maybe she's not on. Sorry. I thought she was on Zoom, but she's not there.
She had to step off for just a minute, Judge.
Sorry. No, really happy.
No.
Where'd that come from? It's shutting down.
Okay, on the record in the matter of the people of the state of Michigan versus Vincent Matson, file number 22-00976. Council appearance.
Brian Rang on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Vincent Matson, who is appearing separately by Zoom.
Maybe it's the date that we set this matter. I think we were still waiting for criminal responsibility evaluation on this. And we were gonna see if you can get an update as to when they estimate they'll do that.
Yes, Your Honor. Don't have an estimated time as yet. Like I asking if they would set it actually, even 6-9 months out. They obviously they can't do it now.
Is it 6 to 9 months out?
Well, I don't know the estimation on when they expect it, but that's why I filed the notice to assert the defense, just so that it's on the record. The court has a note that Mr. Matson reports that he's currently he now has ACT care, so he has daily contact. I talked to his therapist, Mr. was it Keenan DeWitt, He has now being monitored on medicine. ACT usually has people that check in and give you rides every day. He actually found his own housing. He found his own room. So he has a place of his own now. So he's finding some good stability right now.
Very good. Okay, and so a date completely uncertain as to when they can ever, if possible,
Yeah.
get to a criminal responsibility.
I have my social worker like checking in with CFP and continuing to do that. I'm waiting on what she finds out. But that's my intent, is just to make sure that we make that they haven't forgotten about him, that the order doesn't get waylaid, and that he continues to be stable in the community.
Okay. How do you want to proceed?
Your Honor, I'd like to get that criminal responsibility evaluation back for a determination made.
Well, I'm willing to give it another adjournment. I'm not willing to adjourn this matter for another 6 to 9 months, though.
Understand,
I don't see how that's in the interest of justice. I don't even know if we still have a victim that's a participant in this case. And the longer this progresses, the less likely we'll have access or communication with the victim. I'll set it out for another couple months, 60 days at this point, and then see if we get some updates from the forensic center. My inclination is it's likely it's still going to linger at the bottom of the barrel with felonies taking precedent.
Right. Understand, Your Honor. Thank you.
But I'm glad to hear that Mr. Matson is doing well. It looks like he's doing well, and it's in his place now. Another date, please. 60 days, please.
We can do December 20th at 9:30.
December 20th at 9:30. Thank you. Any additional matters for the record?
Nothing in favor, Your Honor.
None for defense.
Okay, we're off the record. Thank you, Mr. Matson.
I'm unmuted.
What am I doing?
Okay, Ms. Martinez. Good
Good morning, Your Honor.
morning. Sorry, we have a multitude of issues in courtroom for today. We got uncontrollable heat. We've got no working court reporter computer, and we got a jury on the way.
If we need to adjourn, that would be fine because I'm working on some materials to provide the prosecutor. So I have no problem with the new date if that helps the court.
Yep, that helps the court. We'll get you a new date. Thank you. Yes.
Just so Ms. Martinez is aware, hi, Ms. Martinez is Ailish Gallagher. Just so you know, the victim is present in the courtroom. I just wanted to let you know, and so that when you're discussing the resolutions and all that, that you know that part.
Thank you. I appreciate that, Ms. Gallagher.
Okay, let's see. And so you're here for Mr. Is it Stachulski?
Stachulski, and he is present on
Okay.
Zoom.
Correct. Okay, sounds good. Let me get them a new date. He was on here, but did we lose him? No, he's still there.
We can do November 1st at 10 a.m.
Okay, November 1st at 10 a.m. Does that work for you, Mrs. Martinez?
Let me check here. I actually have another matter at that time. Is it possible to get a different date?
Does November 8th work?
Yes, it does. Thank you.
We can do 9:30.
Okay, that's what we'll do. Thank you, Mrs.
Thank you.
Martinez.
Eddie, I'll give you a call.
Thank you.
Bye.
I don't know who is T. I know who this is. Okay. Hi, what's your name? Hello?
Bush.
Ernest Bush. Oh, sweet. All right. You need to speak to him? Yes, I do. Okay, one moment, your attorney needs to speak to you.
Okay, thank you.
Hello?
Hold on, Mr. Bush, I'll get us into a breakout.
All right.
Oh man, what is going on here?
All right, Mr. Bush, we have it set for November 1st at 10 a.m.
Okay, yeah, because I'm holding the money order in my hand for the other ticket, and I know I got the money order, the ticket number and stuff on the money order. So
All right, go ahead and check it. I'm gonna check with the court and then we'll come back November 1st, 10 a.m.
all right, thanks.
Yep, thank you.
Good morning. Who's on the iPhone?
Jessica.
She's Mr. Mark.
What's your name, ma'am?
Jessica Banks, Banks.
Okay, just a moment.
Thank you.
Ms. Banks, you're actually supposed to be with Judge Ward. Do you have her Zoom ID?
Foundation.
Well, I just think it's.
She has ours.
Is that the 934-285-9288?
Yes, that's exactly correct. So you need to log into Judge Ward's right now, okay?
Yeah, yesterday.
Oh, no, I just said to me.
Okay.
You have like.
All right. Mr. McConnell, are you there?
Yes, sir.
Do you have an attorney, sir?
No.
Moment. Mr. McConnell, we'll put you in a private meeting room with the prosecutor, okay?
Mr. McConnell, can you hear me?
Yes, sir.
Your case was reset to November 1st at 10 a.m. and that's via Zoom, the same way you logged in today, okay?
Sounds good.
You're all set. You can hang up.
All right, thank you.
It's okay. So you can just have that. We don't need to see anything, or I can have them.
On the record in the matter of the people of the state of Michigan versus Joyce Jenske, phone number 21-03487, council appearance.
Thank you, Your Honor. Alicia Gallagher on behalf of the people standing by APA Brian Ring.
Brian Ring will be up.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Joyce Jenske, who is housed in Ingham County Jail, and it's my understanding refusing to leave her cell to participate, and so I would be waiving her appearance.
Say this, the date that was set. At least the date that we're going to address, competency, the court did not receive a report, but we did get a copy by way of prosecution. Yeah, the prosecutor looked like they received this back on September 19th. We did not receive one. Nonetheless, this report dated for September 15th, 2022 will find that this is not for this time.
No, you're right.
That's
You're
why
right.
we didn't get it.
Mhm. Your order went to CFP, and I believe what happened was they dropped they said that they weren't gonna take any further actions after Ms. Jenske refused to cooperate. But she got another case out in front of Judge Hillman, and the prosecutor's office petitioned her for competency on that case, and they had her brought in person for that interview. So that was completed.
So it looks like at least on Judge Hillman's case, file number 22-00972, she was deemed incompetent back on September 15, 2022.
Your Honor, I believe what's happening is that Judge Hillman did order her for treatment because it found was restorable within the time frame. So she's still in Ingham County Jail, obviously, but that's what they're currently.
I think my concern though is, yeah, they need to send me a report on my order. They didn't even send me anything saying that they would not evaluate her. So I'm gonna adjourn this, and Mr. Big will get in contact with them. They gotta send me something. If they say there's nothing they can do because she was uncooperative, then I'll have to adopt the record from Judge Hillman's case incorporated, but they didn't even send me anything. The last thing I have is that it's from July. Except that they will schedule another appointment. So we shall follow up with them. This was not scheduled at all, I would say. Let's schedule it for next week. October 25th at 9:30. Any additional matters on this record today?
None for defense. Thank you.
Okay, sounds good. Let me see. Brian Gibbs, was that reset?
No, Your Honor, that he should have appeared. Let me see where. Jasmine James, I didn't expect to be here though.
James Jones will appear within benchmark. 1, 2. What time?
For the jury instruction where we're introducing counsel, do you mind if I switch the prosecuting attorney to, not list me and then I could just introduce myself as co-counsel? Is that okay, Your Honor?
I have no preference.
Okay, thank you.
Hi, who's in the jail?
Yeah,
What's your name?
Mark Pierce.
You ready on Talia Payne?
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Talia Payne. File number is 15-00894. Council appearance.
Alice Gallagher on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Talia Payne, who is appearing separately by Zoom.
There's a date that was set for a pre-trial. On a driving while license is suspended. How are we proceeding?
Your Honor, at this time, Ms. Payne is almost almost able to go apply for her license. It's my understanding that there is a failure to appear in court suspension on this very case. I don't know why though, but if we can, as long as we can figure out how to clear it, she should be good to go apply for her license. And then at that point, we just need probably 60 days so that she can pass the written and driving portion.
I'm pretty sure the failure to appear has something to do with why this case is from 2015.
For the older ones?
This is from 2015, so she probably
Yeah.
never came before.
Yeah.
Okay, well, we'll reset it 60 days, you can get that situated.
December 20th at 9:30.
December 20th at 9:30. Do you have any questions today, Ms. Payne?
No, Your Honor.
Okay, any additional matters for the record, counsel?
None, Your Honor, thank you.
No, Your Honor, just so that we're clear that, or have we cleared the suspension that was on this? Or
I'm not sure what's on there.
Okay.
And we'll have to deal with it at another time because I'm calling, I said I was calling the jury at 10:30.
Okay.
So if that's the case between now and then, just bring it to my attention and I can get it cleared.
Okay, all right.
Excuse me, Your Honor.
Yes, ma'am.
I was told by the Secretary of State that I couldn't apply for that with any current bench warrants or anything pending on my driver record that wasn't resolved. So until then, I can't even apply.
I agree. Your attorney is going to make sure on our end that if there's a court hold that we get that taken care of so that you can move forward with the Secretary of State, okay?
Thank you.
No problem. Any other questions?
No, Your Honor.
Okay, you're all set. Thank you.
Thank you. You guys have a blessed one.
You too. Did you need to speak to Mr. Pierce?
No, Your Honor, I don't.
For the record in the matter of the people of the state of Michigan versus Mark Edward Pierce, file number is 22-01691, council appearance.
Brian Ring on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Mark Pierce, who is appearing separately from the English County Jail.
Today's the date that is set for a pretrial on the littering. How we proceed on this?
Your Honor, at this time, we would proceed with a plea, but we're trying to figure out whether there's going to be restitution owed to the cemetery, but it's my understanding that Mr. Ring, you haven't been able to get a hold of him.
Right, I reached out to the cemetery at least once this week and left a voicemail for a callback and have not received a callback yet.
So, Your Honor, I would be ready to proceed with plea and hopefully sentencing, if not, but sentencing eventually, if without the restitution, given the fact that the prosecutors can motion for it afterwards. But if they're adamant about restitution, then I would at least take the plea and set out sentencing so that hopefully resolve it together.
Oh, so he wants to plead to the charge?
Yes.
Mr. Pierce, you want to plead guilty to the charge of littering on private property?
Yes, I do.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can put your hand down. Mr. Pierce, you're represented by Ms. Donnelly from the Office of the Public Defender. You have the right in this matter to proceed to a trial. You have the right to have a jury trial or a non-jury trial. You have the right at trial to be presumed innocent until proven guilty. You have the right to see, hear, or question any of the witnesses if this prosecution intends to call. You have the right to remain silent and not have silence be used against you. You have the right to present evidence at trial that you believe would further defense to this charge. You would need to give up each of these rights, including the right to have each element of the charge being proved beyond a reasonable doubt if you want to plead guilty today. Is that what you want to do?
I want to plead guilty today. Thank you.
So you want to give up your rights?
Yes.
Okay, anybody threatening you to get you to waive your rights and plead guilty?
Nope.
Were there any promises made to you to get you to waive your rights and plead guilty?
Nope.
Are you pleading guilty because you believe you are guilty?
I know I'm guilty.
Very good. And you understand that this is a misdemeanor with a maximum penalty of 90 days in jail and or $500 in fines. You understand that?
I understand.
You also understand that there is a potential of restitution being owed to the cemetery, correct?
I understand that. The only thing I'm going to say is I'm on probation. I'll be on probation for a long time, and I've got fees and costs with that, and I'm on Social Security disability. So the restitution is going to have to wait in line.
Is that what you believe?
That's what I'm saying is I owe a lot of
Oh.
money, right?
Okay. Anything else you want to add, sir?
No, ma'am.
Okay. As to count one of littering on private property, how do you plead?
Guilty.
Okay. Factual basis, please.
Thank you, Your Honor. Mr. Pierce, on or about November 10th of 2021, were you at 845 East Miller Road in the city of Lansing, Ingham County, state of Michigan?
I'm sure I was.
All right, and about that time and place, did you dump large household furniture items like mattresses, box springs, chairs, bookcases, that sort of thing?
Yes, I did.
All right, and did you, and that was on the premises of North Cemetery, correct?
Right.
And did you deposit that refuse on the grounds of North Cemetery without permission?
Yes, I did.
All right, Your Honor, I have no further questions.
Any questions from the prosecution? Court is satisfied with the factual basis, and I will accept this plea and find your plea, Mr. Pierce, to be made freely, voluntarily, and intelligently. I'm gonna set this matter for sentencing. That'll give the prosecution opportunity to get some information back from the cemetery. Give me a couple weeks. We can do November 8th. November 8th at 8:30. Do you have any questions today, Mr. Pierce?
The only thing I ask is, does my PR bond continue?
Can you speak up for me?
Does my PR bond continue?
Hold on. Mr. Pierce, you do have a personal recognizance bond on this case. It's your other case that's holding you in. We're working on it.
I know I'm going to post bond. I'm going to be trying to get out tomorrow, so I want to make sure that I'm clear to go.
On this matter, you have a personal recognizance bond.
Okay, thank you.
Thank you.
So is that it for today?
That's it for today.
Okay, thank you.
No problem. Let's see. Well, they're coming upstairs now, because what, I have a quick question. Why are we adding 2.12 to instructions before trial?
So question.
Oh.
I didn't catch.
That's
it.
on the procedural.
Sorry, I wasn't sure if Your Honor allowed questions from the jurors, so I wanted to ask if that was okay before adding it.
Well, 2.12 is in my procedural instruction.
Oh, I'm sorry.
Oh, yeah.
Thank you.
That's why I was wondering why.
I'm sorry, that was my bad. Thank you.
That's on there. We have two more people appeal. Let's see who we have.
Yep.
I'm not addressing Mr. Gibbs, he's 30 minutes late.
Okay.
You can give him a new date. November 1st at 10:30. Mr. Gibbs, you need to come back November 1st at 10:30. You need to be on time, okay, sir? You were 30 minutes
Yes,
late
ma'am.
today.
I
We have a
know.
jury here.
Could I make a request though, please?
What's the
If at all
request?
possible. Is it at all possible to aim for like the early afternoon for our court time? I do work until 4 o'clock in the morning.
1:30. The same day at 1:30.
So forgive me, you said November 8th, right?
November 1st at 1:30.
1:30. I do appreciate this, and hopefully it'll stop me from being late or missing even. I do apologize for that entirely, wholeheartedly.
No problem. We'll see you on November 1st then, okay?
Thank you, madam. Or
No
sorry,
problem.
thank you, Your Honor. Sorry.
You're welcome. Okay.
You'll have a wonderful day, and sorry for being late today.
Thank you. No worries. Are we taking a plea on Glasgow today? On Glasgow?
Your Honor, with for Glasgow, the restitution, I think, is an important enough issue when it comes to even accepting the plea. So Mr. Ring has informed me that he is still making efforts to try to find that.
So you need a new date.
Especially if they're going to keep, they're going to insist on it. Yes, Your Honor.
Okay, great. We'll get a new date. Couple weeks. I need another purple pen. I would. Restitution. November 1st at 10:30. Ms. Glasgow, we're resetting your matter to November 1st at 10:30.
Okay.
Okay, thank you.
Have a good day.
Same to you.
Thank you.
Okay, I think we're ready to bring the jury.
Yeah, I mean, usually though, I agree, I just. We do not tell them if they understand the position.
Exactly. Yeah. So, yeah, we want to do that next time. So, I mean, yeah.
Just so that we don't.
And I don't want to look up either, just. For two weeks, and all of a sudden it becomes like $2,000-3,000 restitution. Then one, she take, she regrets cleaning it all.
Yeah, I'm not the fashion machine.
Well, I mean, yeah, well, it would be granted in the Rights Act, so the amount of accepting and stipulating should be worth one. I just don't want to change. Informed decision, I just want to make sure. Mr. Pierce, he was really pretty guilty either way. Yeah, the restitution on that. Yeah.
I just found.
Oh, great, yeah, he's probably been trying.
I think I found our DB victim's real number.
Oh, I know her number, I represent her. Yeah, I represent Jasmine. Jasmine Perkins, oh yeah, I've got two numbers for her. I've got it, but I'm conflicted out of that.
On the 11th, I got something.
I'm not really understanding what's happening here.
Oh, so the 11th, maybe it'll just take a little bit. Maybe we'll get this.
Email back on the 14th.
Oh, it's not.
Response.
So what?
Why is not this? In my
Yeah.
screen.
This one is full screen. do that.
That's really nice, Your Honor. Having us there.
I know, if it works,
We should do it on
it gets
Sunday.
glitchy. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that may influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. All rise, please. And can you raise your right hand? Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in the case? If you do so, say it, you will. I will. Thank you. You can put your hands down and be seated. I'm going to introduce some of the people in the courtroom. We have my court staff, my court reporter sitting here to my right. Her name is Miss Addie Nash. I have a court reporter here in this nice fine tan suit, and that is Mr. Nicholas Bigelow. This is a criminal case and it involves the charge of assault or assault and battery, and I will explain that a little later. This charge has been made against the defendant, who is Heather Thalen. The defendant's attorney is Sarah Donnelly. Mrs. Donnelly, please list any witnesses you anticipate calling in this trial today.
Your Honor, I anticipate calling my client and my client's daughter, Ms. Elizabeth Raleigh.
Thank you. The assistant prosecuting attorney is Mr. Brian Ring, who is also sitting at counsel table, and assistant prosecuting attorney Ailish Gallagher, if you want to stand and list any witnesses you anticipate calling today at trial.
Thank you, Your Honor. The prosecution intends to call Leoma Scott, Caden Stevens, and Miranda Stevens.
Does anyone in either the jury box or waiting to be chosen to possibly go to the jury box know the defendant or any of the lawyers or witnesses? If you do, you can just raise your hand. Okay, no hands are raised. We think this trial will last for 1 day. just today. We don't expect to come back another day for this. If you believe that being here for a few hours today would be a real hardship to you, you can let me know now by raising your hand. Very good. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 to 3 hours at a time? Or does anyone have a sight or hearing problem? So let's take the sitting issue. We're not going to sit for 2 to 3 hours straight because I can't sit for 2 to 3 hours straight. We will take breaks. If we go an hour at a time, I give a break at the top of each hour when appropriate to do so. But again, overall, you will be sitting for a couple hours while the parties present their evidence. Is that presenting health issue for anyone here today? Okay, can everyone hear me clearly? Anybody need a device to assist them with hearing today? And sight, everyone can see clearly in here? Okay, very good. This is a criminal case. The paper used to charge the defendant with the crime is called a complaint. The complaint in this case charges the defendant, Heather Thalen, with the crime of assault or assault and battery. The complaint reads as follows, that the complaining witness says that on or about September 18, 2019, at the area of 1652 Strong's, City of Lansing, Ingham County, State of Michigan, that the defendant, contrary to law, committed the act in count 1 of assault or assault and battery, and that the defendant did make an assault or assault and battery upon the following person, Leoma Scott, and that this is contrary to Michigan Compile Law 750.811. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal case so that the defendant and the jury can hear the charges. You must not think it is evidence of her guilt or that she is guilty because she was charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or impossible or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. And so I'll let the attorneys begin their voir dire.
Thank you. Morning. As the judge said, my name is Brian Ring. So I'm just going to start with a few questions. Has anybody ever sat on a jury before? You have. What kind of case was it?
It had to do with a kid possibly threatening another children, but with a gun, one of his friends.
So it was a criminal case?
Yeah.
Did you reach a verdict on that?
Yes.
Thank you. So has anybody ever been involved in law enforcement? So speeding tickets, any other involvement with law enforcement? Had to report a crime? You had to report a crime? What kind of crime did you have to report? Assault. Assault? Yeah. Were you the victim in that crime? No. You just see that crime happening? Yeah. You have to give a report to the police? Yes. Was it a good overall? Was it a good interaction with the police for you, or was it a negative interaction?
Interaction was fine. Just that his police report didn't
state what was told to me. Police report didn't accurately state what they told. Okay, thank you for that. Is there anybody else that saw?
Just
Yes.
for the record, that was Dirt too.
Thank you.
Sorry.
A sexual assault thing.
Ms. Roper?
Yes.
Juror number 6, thank you for that. You reported a sexual assault back in 2008?
Yeah.
Were you the victim in that?
Yes.
And how did that interaction please go for you? So overall with the police, did you feel that they accurately took down what you stated happened?
It was caught.
Sorry, I didn't hear
They
you.
actually caught him.
Oh, okay. Thank you. Does anybody else want to agree?
I'm not sure if it's him, but I reported someone breaking into somebody's car.
Juror number 4, Ms. Helmet. Yeah. So you reported somebody breaking in. Did you have any interactions with the police
Yes.
during that time? Was it overall a positive experience or a negative experience? Do you feel that they accurately reported what you took down or what you stated or what you said happened?
Yes.
Thank you. Did they ever? Juror number 5, Ms. Taylor.
I don't know if this is what counts as interaction, but I am relative to our police officer.
Okay, yeah, I was gonna lead into that next. Thank you for that. Thank you for that
Let me
segue,
stop
that
you.
good segue.
Did you have a question or were you trying to answer his question?
I was trying to.
I'm sorry?
I was trying to answer. I'm not sure if mine.
Okay, yeah, you don't need to enter unless you make it into the hot box. So you're safe for now.
Keep that in mind in case you come up here and then we can have a little discussion, okay? So thank you for that segue. Does anybody here have any friends, family involved in law enforcement? Kind of raise your hand there, Ms. Hooper.
I've got a brother-in-law who is a state police.
You have a brother-in-law. Is it here in Michigan?
Yeah.
You interact with him fairly often?
Yeah.
Do you discuss his work and does it tell you about like the kind of cases he's working on or kind of
No.
what happened during his day or?
No.
Okay, thank you for that. So like the judge said, this case is about an assault and battery. Has anybody here been assaulted? Ms. Cranville?
Yeah, it was a domestic.
You were a victim of domestic assault. Did you report that?
No.
No. And so with being a victim of domestic assault, do you have any reservations about sitting on the jury and hearing testimony about an assault that occurred? With that?
I think it would depend on the case. But no,
Would you be able to unbiasedly, I guess I would say judge the defendant based on their actions, knowing what you've been through?
yeah.
Thank you for that. Has anybody here gotten angry today? Upset? Within the last week, has anybody been angry or upset? About anything. It could be anything. I mean, I was driving in this morning, somebody cut me off and I got upset. I just yelled a little bit in my car, and continued on. Has anybody ever been upset this week or angry at somebody? Go back to the last month. Anybody been angry or upset in the last month at somebody? All right, Mr. Jones, how'd that interaction go?
I'm just angry. I mean, I've never interacted with a person that said driving incident. And you do it all on the phone driving, so.
And you just got angry. You say a few words.
Because he wasn't doing the speed limit because he was too busy doing this.
You
I
said
was trying to get into work.
You didn't.
I was almost late.
You didn't chase him down. You didn't do it.
No,
You just. Thank you for that. And I saw another hand. I missed it though. Miss Taylor. Yes, you're on fire.
I was gonna say, just at the news.
You get angry at the news. You don't. When you get angry at the news, do you punch your TV? Do you
No,
you
I
throw?
just yell.
You just yell at your TV. That's fair. Has anybody ever been so angry that they wanted to hit somebody? I see you nodding your head, Miss Hooper.
I don't think anybody's not ever wanted to hit somebody.
That's fair. That's a valid emotion. And did you react on that emotion to hit that you wanted to hit somebody, or did you?
No.
Okay, thank you for that. So when this trial is going to involve I had my witness list. This involved testimony of the witnesses. Is there any type of evidence that you as a juror would like to see in an assault and battery? Mr. Is it Barrera? Is there any type of evidence that you would like to see, that you'd be looking forward to seeing in this assault and battery?
Guess it just depends, maybe pictures or
Okay.
some form that to, like prove that, what's going on.
And that's fair. So you're not gonna get a copy, you're not gonna get a copy of the police report. Is that gonna negatively affect anybody's opinion on the case? If they don't receive a copy of the police report or receive any medical records? Is anybody looking for medical records? Or a medical history that shows that they were injured?
I mean, that's kind of proof that something happened to you and show that. I don't necessarily myself always need it, but that would be more proof that something was done to you.
Okay. Thank you for that, Mr. Jones. Ms. Roper,
Yeah.
if only my victim got up and testified, and you thought in your mind, you believed her beyond a reasonable doubt. And I put on no other evidence, but you believe that every element was met and that she was assaulted, would you be able to convict just based on her testimony alone?
The evidence got
And the evidence would be just her testimony. If you believe what she was saying and thought she was credible.
Yes, I could.
And I'm gonna same question to everybody. If you don't think that you could do that based on just the one witness's testimony, could you please raise your hand and let me know? Thank you for that, Mr. Jones. And
There's not even a he said, she said.
there might be a he said, she said, but if you believe just my witness, my victim.
Over the other.
Yep, if you believe just exactly, and I didn't give you medical records, I didn't give you pictures, I didn't give you a police report, I didn't have anybody else come up to corroborate her story. If you believe just what she said, is that enough for you?
Yeah, he said, she said, and I go on who I believe.
So you're gonna have to, in this case, you're gonna have to judge the credibility of the witnesses. And how do you judge credibility? Ms. Cranfield, what are you looking at when you're judging the credibility of someone? How do you know if somebody is telling you the truth or not telling you the truth?
I feel like it's easier when you know the person.
Yeah,
Right?
that's
you,
fair.
you can judge based on what you know about them. So as a complete stranger, I think it would be a little more difficult. Usually I think I would probably look for consistency of stories, but if there's only one person, one story, I don't know. I've never done this before, so I guess it would just, you'd get some sort of feeling, I guess, from them. If you think they're being authentic or not.
Does anybody on the jury have kids? Ms. Hellman, how many kids do you have?
2.
You have 2 kids. Are they younger or are they older?
They're both high school.
Okay, so when your kids were younger, did they get into things? Did they tell on each other and you had 2 conflicting stories about what happened?
Yes.
How did you judge Yeah, I know your kid, you could probably tell you kids have tells on which one's telling the truth. How did you judge the credibility of which one was telling you the truth and which one wasn't?
It was something with body language.
Body language?
Yeah.
Okay,
Yeah, and the way they're presenting it.
that's fair.
Yeah.
Who else had kids? Ms. Hooper, that's the same question. You both your kids, they're both telling you the same stories. How would you judge that credibility?
Usually, if it wasn't really evident by their stories which one was guilty, they both got punished.
I have 2 kids myself, and sometimes it's difficult to tell which one's telling the truth and which one's not.
Yeah.
Does anybody here watch television? Does anybody here, you watch crime shows? Does anybody watch crime shows?
Yeah.
Mr. Jones, what crime shows do you watch?
First 48, CSI, but not like the one that's make believe CSI, the actual CSI where they do investigations on crime that really happened, stuff like that.
Thank you. And I saw a couple other hands. Can you hold those back up, please? Yes, I'll go with Ms. Helmick. Which ones do you flash?
First 48, Joe Penda's contact on her. Body cam.
And I believe Ms. Roper, you had your hand up.
The same ones.
Same ones. Does anybody listen to any crime podcasts? Does everybody believe that, does anybody believe that the court is exactly, and the crime scene investigation is exactly how they see it on those shows? Does anybody have that expectation that it's gonna be exactly like that? Thank you. Does anybody have a friend that was assaulted? No. Relative? You have a relative that was assaulted? Were you exposed to that relative?
Yes, no.
You believe your uncle was treated fairly?
From, what do you mean, from within the courses?
Yeah.
I don't know if it was the court, it was just motorcycle gangs like assaulted him.
Okay.
They didn't like how he was talking and whatever.
And were the police involved in that?
Yeah, he went to the hospital and everything, but he couldn't point out which, it was a group of people, he couldn't point out and say this is his person or whatnot, and he didn't know names, so.
And I saw one more hand, two more hands, I missed those. Ms. Taylor.
My sister is a police officer. She was assaulted by somebody.
I'm sorry, I couldn't.
My sister is a police officer and she was assaulted by somebody she arrested.
Okay, your sister's a police officer. Are you close to your sister?
Very.
Does she tell you about her day-to-day interactions and, kind of what's happening?
Not often.
Is she a police officer in Michigan?
Yes.
And I saw one more hand. That would be Miss Roper.
My son.
And how's that affected now?
He's doing fine.
Did you witness it?
No, he was picking his daughter up at the bus stop. And somebody came out of the stop.
Does that affect you?
Careful.
Judge is going to give you what the law is. Does everybody agree to follow that law as the judge gives it?
Yes.
Does everyone agree to not put their personal feelings with either the law, past or present? Does everybody agree to not let those feelings interfere with their decision today?
Yes.
Thank you. No further questions.
Reminder, my name is Sarah Donnelly. I'm the defense attorney. After all those questions, just a few follow-ups. So for those that have witnessed an assault, did you or if you even if you haven't, you can put yourself in a hypothetical situation. So you're witnessing an assault. There are usually, different people, different reactions. Which one of you would anyone who would actually step in and try to like either break it up or feel like they could do that, or would you basically just or would you not intercede? Would you feel like
if it's just, one person, on each side, yeah, I would try to break it up, but if it's a group of people, you really can't get involved in that because if it's 4 people with this person, and you're trying to help this person, then you will be more involved in what you really thought you should be.
Exactly. All right. Would it change if at all the person who is involved in this altercation is someone like you love or someone you're, family member? Okay, so you feel like you'd be more, you would tend more to want to intercede if it was someone in your family. All right. And is that, is that some sort of protective feeling that you have for those people that are included in, your close family? All right, so to what extent would, if you felt like your loved one was in danger of being assaulted or something like that, well, how far would you guys go? Would it to protect a loved one? Like, let's say it was your, like you said, it was your child.
I mean, I don't think nobody in here would help defend their child.
Okay. All right. Besides that, though, you asked about you can be unbiased, right? You see Miss Thelen right here. This is the defendant. You feel like you can hear the facts, hear this case, and come with a very objective, unbiased opinion about the matter. Everyone nodding their heads. Everyone, anyone disagree? Okay. All right. And then, of course, when it comes down to it, you guys, the burden is beyond a reasonable doubt, right? And you know what that means is that basically, if in the end, if it comes down to, let's say, they don't have to present reports, records, anything like that, video. They might have photos, but whatever they present, you will be then given the decision about whether it is proven the elements beyond a reasonable doubt. And therefore, beyond reasonable doubt means if you felt like in the end there was still questions, you would be able to, think about whether that was reasonable doubt or not, right? Okay. All right, Your Honor, I have no further questions.
For the prosecution, any challenges for cause?
None for cause, Your Honor.
Any challenges for cause?
No, Your Honor, we have no reason to for causing or peremptory challenging.
Okay, any peremptories for the prosecution?
The people would like to thank me, excuse juror number 7.
Juror number 7, thank you. And I'm gonna replace seat number 7 with Roy. Is it John Kane?
First name?
Roy. How do you pronounce your last name, sir?
Bianchi.
Bianchi, thank you.
No, Kini.
Bianchi. Okay. And briefly, counsel, can you walk in?
Thank you, Your Honor. Mr. Bianchi, you heard some of my questions. Is there anything during those questions that you want me to know?
My brother's an officer, retired. I did 3 years in the military as an MP. My nephew's a police officer, all both. My stepson was involved in a criminal case that was also part of the same charge you're charging.
Was your stepson the defendant or the victim?
No, defendant.
Your stepson was the defendant. Do you think that would negatively affect your judgment here in this case? Do you think you would bring in your feelings from that into this?
You know, I didn't last time. I'm not going to do this time. I do not like Shiawassee County.
Have you sat on it? Have you sat on a jury before?
Yes.
When was that?
Yesterday.
Yesterday.
And also in Chicago.
Was that a criminal
Civil
cases or civil cases? You were able to come to a verdict on those?
Yes.
You said you were an MP in the military?
Yes, sir.
After that, did you go into law enforcement after you were?
No, I went into security.
Okay. Private security or? And so you've interacted with the law enforcement system frequently?
Yes, sir.
You have a negative opinion overall of the law enforcement?
Only in one area.
What area is that?
Chawatsi.
Right, no further questions.
Any questions?
Thank you, Your Honor. So Mr. Bianchini, did you hear the question about, you have children, right?
I have stuff.
You have stepchildren, but the question that came from Mr. Ring was about, with the rest of the jurors, was about if you, with your children, if you had small children and, or basically anyone who comes up to you claiming that, two different stories, one of them is in trouble, but the pointing fingers of the other one, how do you determine in the end who did it? Did you hear that question?
Of the children?
Yeah, if you had two kids, you had two minor children in front of you, and they're both pointing, like you have a broken vase in the room, and they're both pointing the finger at each other. How do you determine the truth?
I'm not gonna determine the truth. I'm gonna sit them both down on both sides of the couches and say, you're gonna sit there until I'm done and not angry at either of you. And then they can decide it themselves later.
Oh, you basically give the opportunity to whoever is the guilty party to come fess up.
They won't do that. They're kids. They're not gonna do that. They're gonna settle it themselves.
Yeah. So in the end, you would rather if they settle it themselves as opposed to,
They gotta live together the rest of their lives.
That's true. Yeah, I understand. All right. And then you said that, have you ever personally witnessed an assault?
Yes.
Okay. And at that time, in that situation, what did you do? Did you intercede or did you stay out of it?
They arrested them.
They arrested him. You didn't have to do anything. Okay. All right. If you felt like you were in a situation where, like, let's say a family member or a child were in threat of being assaulted or were being assaulted, would you feel like you would intercede to protect them?
That I would do.
Okay. All right. And then of course, you see my defendant right here. You'll be able to determine, listen to the facts and determine the elements, if they meet them, the prosecution meets it beyond a reasonable doubt without any bias or
No bias.
yeah, or it'll be an objective decision, basically. All right. Your Honor, I have no further questions.
Thank you. Any challenges for cause?
No, for cause, Your Honor.
No, Your Honor, we don't have any.
Okay, any preemptory?
No preemptive. People are satisfied with that.
We are satisfied as well, Your Honor. Thank you.
Okay, ladies and gentlemen, I believe we have a jury. The rest of you, I'm so sorry that you won't be able to serve here, but there's still a chance for you because you're going right down the hall to Judge Ward. So good luck. Okay, be seated. Okay, you can turn your attention back to the screen. We have more instructions. Okay, ladies and gentlemen of the jury, you have been chosen to decide a criminal case, a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Raise your right hand Do each of you do solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged from the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court? If you do so, say I do.
I do.
Thank you. You can be seated. You will get a written copy of the instructions that I'm going to read to you at the end of the trial when it's time for you to deliberate. Since no one can predict the course of the trial, these instructions may change at the end of trial. At the close of the trial, I will provide you with a copy of my final instruction for you to use during your deliberation. Now I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. The defendant is charged with the crime of assault and battery. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon a Leoma Scott. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Leoma Scott's will. It does not matter whether the touching caused an injury. Second, the defendant intended either to commit a battery upon Leoma Scott or to make Leoma Scott reasonably fear an immediate battery. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about September 18, 2019 within the city of Lansing, Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. I'm not sure what's going on with the screen, but it always does this when it's time to choose your instructions. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful and considered examination of the facts and circumstances of this case. Okay. A trial follows this procedure. First, the prosecutor makes an opening statement where he or she gives his or her theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes theirs, or she may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents their evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecution has presented all of their evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, the prosecution has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyers will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of the case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of a person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin, or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long has the witness been watching? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of important questions that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to the court staff. My court officer would be the most appropriate person. And then they will give it to me. Do not show your question to the other jurors. Everyone has a pen and paper? Excellent. If your question is not asked, it is because I determined under the law that the question does not need to be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyer or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to those interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave. Report the incident to court staff as soon as you return to the court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So, to be fair to both sides, you must follow this instruction. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect and misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case. including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group. Under court supervision, you must not consider as evidence any personal knowledge that you may have of the scene. You must not share any information about this case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to my court staff. You may take notes during the trial if you wish, but of course you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see that we have chosen a jury of 7. After you have heard all of the evidence and my instructions, we will draw lots to decide which one of you will be dismissed to create a jury of only 6. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following their closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. After my instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusion about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. Okay, that concludes the procedural jury instructions. It is about 1:45. I am not going to start with open yet because we need to break for lunch. I think lunch was being brought in. Correct? Okay, lunch is being brought in, so we're gonna break. I'm gonna release you to the jury room and they will get lunch once it's brought in. And then after your lunch, we will reconvene and then we'll proceed with opening statements, okay? Remember the instructions that you were given, that you can't speak to anyone that's connected to this case, and be careful with speaking with anybody. You can't speak about this case. You haven't heard anything about it yet. No research, no Googling, none of the above. If you believe there's been a violation, please let my court officer know. All rise for the jury.